God bless the United States and this honorable court. Please be seated.
Good afternoon. Welcome to the E. Barrett Prettyman Federal Courthouse, built in 1949 and 1950. It currently houses the United States District Court for the District of Columbia, the United States Court of Appeals for the District of Columbia, and the United States Foreign Intelligence Surveillance Court. Elijah Barrett Prettyman was a circuit judge of the United States Court of Appeals for the District of Columbia Circuit. He was appointed by President Harry S. Truman. I am absolutely thrilled to welcome you to this 30th anniversary celebration of the creation of the United States Court of Appeals for Veterans Claims. I call this court the Grand Experiment because we are unlike any other federal appellate court in the country. Working at this court has been like walking into a laboratory every day and conducting experiments with the law and legal principles and precedents and creating new law or expanding on existing law. From day one, there has never been a dull moment. Every file that I have touched among the thousands that I have reviewed over the last 15 years has represented a veteran's life. And every time I dig deep into that veteran's claims file, I know that what we do at this court will impact a veteran's life. The United States Court of Appeals is unique, for veterans' claims is unique. In some ways, we are like a district court. We decide cases as single judges. But unlike a district court, we are largely prohibited from finding facts. Our ability to make factual findings is extremely limited and generally left to the administrative agency below the Department of Veterans Affairs. Unlike a district court, we don't conduct trials. We are not a district court, but we have class action authority, like a district court does. We also decide cases in panels of 3 or more for precedential decision making, like other appellate courts, or sometimes the full court will meet en banc. We decide cases on legal issues and on the application of law to facts. We hold oral arguments here in Washington, D.C. and around the country. We are subject matter experts on veterans law, the only federal appellate court created exclusively for veterans who may be dissatisfied with a disability determination result from the Department of Veterans Affairs. We are the newest and most unique federal appellate court in the country. Joining me on the bench are my colleagues, Judges Schoelen, Peach, Bartley, Greenberg, Allen, Meredith, Toth, and Falvey. Behind me are my retired senior colleagues, the court's first chief judge, Frank Nebeker, senior judges Cassold, Hagel, Mormon, Lance, and retired judges Farley and Ivers. Before we begin, I am pleased to welcome a few special guests joining us today. From the United States Court of Appeals for the Federal Circuit, Chief Judge Sharon Prost is here, as well as Judges Todd Hughes and Raymond Chin. I think the Circuit Executive is here as well, Peter Marksteiner. From the Department of Veterans Affairs, I'm honored to welcome Cheryl Mason, Chairman of the Board of Veterans Appeals, William Hudson Jr., Acting General Counsel, Richard Hippolyte, Deputy General Counsel, and many other representatives from across the Department of Veterans Affairs. I'm also grateful to our speakers, who you will hear more from in just a moment. I'm also pleased that we are joined by congressional staff from both the United States Senate and the United States House of Representatives, as well as representatives of veteran service organizations, including the American Legion, the Disabled American Veterans, the American Veterans, and Paralyzed Veterans of America, folks from the Veterans Pro Bono Consortium Program, the National Organization of Veterans Advocates, and the Court of Appeals for Veterans Claims Bar Association. I see current and past members of the Court's advisory committees, to include the Rules Advisory Committee, the Committee on Admission and Practice, the Court's Judicial Advisory Committee, and the Court's Historical Society. And last but certainly not least, I am pleased to welcome my family and friends and all other friends and family of Judges Schoelen and Judge Bartley, and of all the friends and families of my colleagues on the Court. Thank you all very much for being here. The United States Court of Appeals for Veterans Claims is a national court of record and the newest federal court in the country, established in 1988 under Article 1 of the Constitution of the United States. The court has exclusive jurisdiction to provide judicial review of final decisions from the Board of Veterans Appeals, the appellate tribunal within the Department of Veterans Affairs. As such, this court is the only means by which a veteran or a veteran survivor can have an adverse decision from the Department of Veterans Affairs appealed outside of that department. And it wasn't until this court's creation that veterans could take their cases to court to seek justice. On November 18th of 1988, President Ronald Reagan signed into law the Veterans Judicial Review Act, creating the United States Court of Appeals for Veterans Claims, then named the United States Court of Veterans Appeals. Passage of that law was the culmination of decades-long efforts to secure judicial review for veterans. That stroke of the pen was momentous. It set into motion the creation of a court where America's veterans, for the first time in history, were afforded the right to contest decisions denying their veterans' benefits claims to an independent judicial tribunal. 8 months later, in July of 1989, Chief Judge Frank Q. Nebeker was commissioned as the court's first Chief Judge. On October 16, 1989, Chief Justice William Rehnquist swore in 2 additional judges, and that happened in this courtroom. That convocation established a quorum that allowed the court to commence operations. The last member of that 3-judge quorum to be confirmed was retired Judge John J. Farley III. So all this time, Chief Judge Nebeker thought that as the first Chief Judge, he was important. He got the court up and running. But it was not until the 3rd judge was appointed to the court that the court actually began operations. Jack, do you agree with that assessment?
Yes,
okay. Good. Since October 16th of 1989, judges, court staff, and practitioners alike have worked to ensure full, fair, and prompt judicial review of our nation's veterans and their families. There is indeed much to celebrate during the court's 30th year. Today, the final event of our year-long celebration, we will take the opportunity to look back on our short 30-year history and recognize, thank, and celebrate all of the people whose work in the field of veterans law has contributed to fair process for veterans and the resounding success of the court. So today, you are getting 3 ceremonies for the price of 1, plus free food and drinks. In a few moments, the first part of our ceremony, you will hear from several distinguished presenters who will share with you some of this court's rich and exciting history. Next, the second part of our program, you will briefly hear from my retiring colleague, Judge Schoelen, and me. And then the third part of our program, I will pass the gavel to the next Chief Judge of this court, Judge Margaret Bartley, and you will hear from her. The first part of our ceremony is the recognition of the court's 30th anniversary. Diane Boyd-Rauber and Rory Riley Topping are co-authors of the court's forthcoming history book. Diane Rauber is the executive director of the National Organizations of Veterans Advocates in Washington, D.C., NOVA. NOVA is a not-for-profit educational membership organization representing nearly 600 attorneys and accredited agents assisting tens of thousands of our nation's military veterans, their widows, and their families to obtain benefits from the Department of Veterans Affairs. Prior to joining NOVA in September of 2015 as Director of the Legislative Regulatory Affairs, Ms. Rauber served as Associate General Counsel for Appeals and the Paralyzed Veterans at the Paralyzed Veterans of America. In this capacity, she oversaw PVA client representation before the Board of Veterans Appeals, wrote briefs, conducted hearings on behalf of individual clients, provided support and training to PVA service officers, and analyzed cases for potential appeal to the United States Court of Appeals for Veterans Claims. Ms. Rauber received her BS in Communication Disorders from Penn State, a Master's in Education and Special Education from the University of Pittsburgh, and her Juris Doctor degree from the Catholic University of America School of Law. Joining her will be Rory Riley Topping, the founder of Riley Topping Consulting. Rory provides strategic, innovative, and actionable solutions to her clients by utilizing their extensive knowledge of veterans issues, communication strategy, law, and policy from having served on all 3 branches of government and a national nonprofit. In addition, Ms. Topping currently serves as a legal and political analyst for Spectrum News 1 Ohio and an opinion contributor for the Hill newspaper here in Washington, D.C. Previously, Ms. Topping served as a litigation staff attorney for the National Veterans Legal Services Program, where she represented veterans and their survivors before the United States Court of Appeals for Veterans Claims. She also served as staff director and counsel for the House Committee on Veterans Affairs, the Subcommittee on Disability Assistance, and Memorial Affairs Chairman Jeff Miller, where she played a pivotal role in helping the committee investigate and uncover the appointment wait time scandal in 2014. She also clerked for Chief Judge Lawrence B. Hagel at the United States Court of Appeals for Veterans Claims, and additionally, Ms. Topping served as Associate Counsel to the United States Department of Veterans Affairs, Board of Veterans Appeals. Ms. Rauber and Ms. Topping.
Good afternoon, everybody. Diane and I were asked to talk a little bit about the court history book to get today's event started. The book itself has a little bit of its own history. The first generation of judges had looked into having a history book written back in 2000 by Professor Fox, who's here with us today. And at the time, they ultimately decided that the court didn't yet have enough history and the project was pushed aside. When Chief Judge Davis arrived at the court, he was also interested in writing a history book, but soon realized being a judge is a full-time job. However, he did have the foresight to interview all of his first-generation colleagues as they were getting ready to retire, and those interviews have proved immensely helpful in this project. The idea was revived in 2015. We've been working on it since. Initially, then Professor, now Judge Allen, was part of the project, and we set out to tell the court's story. The central theme of the book is that the story of the court is ultimately the story of the people involved with it. Involved in its creation, involved in setting it up, and involved in growing its case law, and ultimately involved in ensuring that every veteran has their day in court. As Judge Allen observed when I interviewed him for this book this summer, he said it's kind of crazy to work in a place where there are still people here on the day that the doors opened. The opportunity to speak with some of those people has been one of the most interesting things about this project. Part 1 of the book tells the story about the VJRA and how the court was created. Spoiler alert, the law passed. We've all heard the term splendid isolation before. The term was originally coined by law professor Robert L. Rabin of Stanford Law School. The phrase subsequently appeared in a House bill report for the VJRA and in the Supreme Court's decision in Gardner. I reached out to Professor Rabin, who is still teaching at Stanford, and asked if he knew what an influential phrase that he'd coined. He actually had no idea, but stated he is pleased to hear that it's regarded as descriptively useful and appeared in other distinguished sources. I want to talk just briefly about some of the unsung heroes of the court's creation. We all know the general story and the congressmen and senators who are at the front of it. But as is often the case, there are many people working hard behind the scenes. For those of you who attended the court's 20th anniversary celebration, you may recall that Bill Brew gave remarks about the VJRA's passage. In those remarks, he mentioned a man by the name of Dean Phillips, and I'm guessing that even if you remember those remarks, you probably don't remember that reference. I want to talk about Dean Phillips again because he is one of the unsung heroes of the court's creation. Phillips was a Vietnam veteran who was also an attorney. When he returned from Vietnam, he left convinced that the war was being fought by men at the bottom of the nation's socioeconomic ladder and was determined that they should never be denied full veterans' benefits. It was because of this that he began to push for judicial review. He was an advisor to Senator Gary Hart of Colorado, who introduced the first Veterans Judicial Review Bill in the Senate in 1976. Although we know that the legislation wasn't passed for 12 more years until 1988, it was Phillips who was able to keep people motivated, interested, in understanding that veterans and stakeholders shouldn't give up and to keep pushing for judicial review. Ultimately, Phillips passed away before the VJRA's passage of cancer that was likely due to Agent Orange. But in many ways, the jurisprudence of this court is part of his legacy. I hope we'll continue to acknowledge Dean Phillips at future events when we discuss the court. One of the other unsung heroes of the court as it exists today is Chris Clay, who currently serves as the general counsel of DAV. Clay was one of the ones who pushed the idea of the court as an Article I court early on. Many people simply remember that some of the VSOs were initially opposed to judicial review. What's lesser known is that Clay, who was an associate at a law firm with DAV as a client at the time, knew about the tax court as an Article I court and recommended to his senior partners that an analogous court for veterans be created. This was important because when DAV's position shifted, the momentum in the House changed, where they had previously been opposed to judicial review to wanting to work out a compromise and ultimately create an Article I tribunal. With that, I'm going to turn it over to Diane, who's going to talk a little bit more about the court's early years.
So I want to pick up on Rory's take on what we hope you might find interesting in the book. One thing we work hard to portray is the evolution of the court's identity and how it has been understood or misunderstood over the years. For example, at least some members of Congress initially envisioned an oversight role over the court and its work. Here is a quote from what one congressman said when Chief Judge Nebaker refused to appear at an oversight hearing in 1990. "It's our oversight of the court. We established it, and we can do away with it. We want to know whether or not it's functioning, and yet, once the guy picks up his robes, he's gone. I'm disappointed that Judge Nebaker has declined to give us some explanation as to what's going on here." I know I was pretty surprised when I read that. Although it took a lot of work over the years by many people, I think we all know that his refusal set the tone for the court going forward, and educating Congress, stakeholders, and the public about the court as a legitimate member of the federal judiciary and not an offshoot of VA. We try to capture that process in the book. We also address in great detail the role of the unique single-judge decision process in this court. It starts with Chief Judge Nebaker's initial unease with it being part of the VJRA, to the evolution of its current role through the robust discussion engendered after publication of the Stanford article, and the many, many opinions of judges and stakeholders along the way. It is apparent this topic is still one of great interest, as senators posed questions about it last week to the two current court nominees. In this project, we've had the opportunity to interview probably close to 50 people, including family members of Judges Steinberg and Mencken, and get informal input from many more. As Rory also mentioned, we had the benefit of the interviews Chief Judge Davis did with the first generation of judges in 2005. He has a keen interest in the court's history, and we are so glad he did those interviews. We tended to start every interview the same way as Chief Judge David started his, by asking people a little bit about their background and how they got to this area of the law. As in many conversations, there are digressions and sidebars. We heard a lot of interesting stories and opinions about all aspects of veterans law that are not going to make it into the book. So we want to promote the Court's Historical Society. They have supported the book project, for example, organizing the many pictures the Court has taken over the years. In turn, we have transcribed the programs the Historical Society has hosted over the past couple of years. We hope that through the book project, we have helped the Court and the Historical Society expand their archives in a way that can be used for other projects in the future. If you aren't a member of the Historical Society, you should be, and we'd be happy to lighten your wallet at the reception of the $50 annual dues for 2020. You can also see John Gaffney or Brad Hennings, the Society's president and vice president, who I know would also be happy to take your money. In closing, Rory and I want to thank the Court's Book Committee, headed by Judge Schoelen, with Chief Judge Davis, Judges Bartley and Allen, Greg Block, and Laura Nash for their help and feedback. They too have logged a lot of hours on this project. We also want to thank members of the court staff who have helped us, in particular Allison Fentress, Lori Jackson, and Alice Kearns, and everyone who's agreed to participate and work with us. We hope you will enjoy the final product. Thank you.
Thank you, Diane and Rory, for those interesting and kind remarks. Professor William Fox is our next speaker. He's the former law dean, professor, and distinguished scholar of the early court. In fact, when I joined the bench in 2004, Professor Fox's work was one of the few treatises out there available to look to for some information on veterans law, in addition to the NVLSP treatise. Professor Fox serves as a visiting lecturer in India and China, as well as other places around the world. He's been a practicing attorney and professor of law for more than 45 years. He is currently serving as a distinguished visiting professor at Peking University School of Transnational Law. He also lectures in the Institute of Law at Nirma University in India. He began teaching in 1973 at Boston University Law School and continued his teaching career for 31 years at the Columbus School of Law at the Catholic University of America, where he also served as Dean of the Law School from 2003 to 2005. Professor Fox has worked as an attorney or served as a law professor in more than 30 different countries and was designated the Paralyzed Veterans of America Veterans Law Scholar in 1994. He is the author of numerous articles and more than 7 books, including The Law of Veterans Benefits. That's the treatise I was referring to earlier. He also served in the United States Army for 6 years. Professor Fox?
Thank you, Judge. Judges, I'm very happy to be here. I'm very happy to see such a large group of people for what is truly a distinguished ceremony. But I want to give you a little personal background, a bit different from what Judge Davis said. I am a disabled veteran. I've been drawing VA comp now since 1967. I finished my bachelor's degree with vocational rehab through the VA, and I did my law degrees on the regular GI Bill. But what's neat about that is I never had any trouble. My stuff seemed just to sail through. So back then I had no idea that there were veterans trying to get claims processed, trying to work with that old decrepit system, and not being very happy. Fast forward. I heard about the VJRA enactment and about the creation of this court. And what I did was I applied for membership in the bar of the court. No problem. I was admitted, but I didn't do anything more. Until 1992, Paralyzed Veterans of America, to whom I'm enormously grateful for supporting my scholarship, put out an announcement. They were looking for somebody to do a bit of research on this court and a writing coming out of that research. I applied, they accepted me, and I started in on that book. Now, I have a background in administrative law, but those of you who have been in law school, particularly law school a while ago, will recall in administrative law, you never saw a veterans case with the possible exception of Johnson v. Robinson, the radiation survivors and statutory preclusion. That was it. So I came to this project as a rookie. Now, one kind of neat thing, and I also need to compliment Judge Allen's fantastic scholarship in veterans law, but one neat thing about when I started this project, I didn't have to worry about plagiarism because there was nothing to plagiarize from.
Right.
But I'm still a rookie. So rookie issue number 1, apostrophes. Apostrophes. Apostrophe in Board of Veterans Appeals, no apostrophe anywhere else. I'm a rookie. And the first thing that goes through my mind is there something very peculiar in veterans' grammar and punctuation that I just don't appreciate? Rookie issue number 2. Citing all the cases, which as you know are blank, vet app, blank. Okay, but we couldn't figure out, me and my research assistant could not figure out, should there be a space between vet and app? Well, as you all know, when you're doing legal research and legal writing, for questions like that, you go to the Harvard Blue Book. Well, bless their hearts, the Harvard Blue Book had not at that time recognized this court. So we had to make our own decisions about space between vet and app or no space. Rookie issue number 3. I didn't know how to organize this. It was such a monumental piece of writing. I spent months just on the outline. I think I spent almost as much time doing my outline as I did actually writing the manuscript itself. And then finally, issue number 4, rookie issue number 4. This came a little bit later, as we were about to go to press on the PVA publication. And I get in touch with Judge Steinberg. And he and I get into this back and forth on reasons and bases. And we were arguing about the conjunction. Is it and or is it and or? Now, quite frankly, this was so long ago, I can't remember what side I was on. But I can tell you that Judge Steinberg and I had this big disagreement. Then, as we're about to go to press without this fully resolved, then General Counsel Lawrence Hagel, Paralyzed Veterans of America, hears about this. And at that time, Larry Hagel exhibited great wisdom. You've seen his truly great wisdom on this court for so many years. And what he told his staff was this: I'm not about to get in the middle of an argument between a law professor and a judge as to what a statute means. So that's the way we solved that problem. Some cases. Henry Quigley. Judge Farley, Henry Quigley, 1 Vet Act 1, if you recall. It captured in 2 pages of decision all of the issues involving this court. A pro se appellant. A pro se appellant was a doctor, not a lawyer. A pro se appellant who was approaching a federal court of appeals. Federal Court of Appeals by writing a letter and asking in that letter that this court enjoin or order the VA to make a decision in this case. Judge Nebaker, that was, I know people are forgetting one bad app one quickly, but we shouldn't. Number one, the court accepted the letter as a pleading. Number two, the court dealt with the applicant, the appellant, with consummate dignity and professionalism. But number three, he was asking for mandamus, and of course the court said no. Quigley, one vet app one, the very first case. Second case, Henry Erspermer, Erspermer versus Derwinski. Radiation survivor, soldier, Army soldier, died. His widow picks up the claim. Mrs. Erspermer is the appellant in this court. Her son, Gordon Erspermer, who is now deceased but did a lot of veterans work, is representing her. And he comes to this court pointing out, unquestionably, the VA has taken more than 10 years to process my mother's claim. Once again, the court took this up with professionalism, dignity. It was an application for mandamus. The court looked at it very closely with a great deal of sensitivity and said no. Now, I talked to Gordon just a few years ago. I was out in California working with him on a project, and his mother finally got her money after 11 years. Judges, 11 years is too long. I hope we never see the likes of Erspermer again. And then finally, Brown v. Gardner, as we say. When my administrative law professor friends look at Gardner, they glance at it and toss it onto a stack of cases that are cases involving Chevron Step 1. It means nothing to them. They never cite it and they never talk about it. But for this court and for this process, it was really substantial. Argued, by the way, by a Catholic University alumni, a former student of mine, Mike Hannon, all the way through. 20 federal judges unanimously agreed in favor of the claimant, including all 9 Supreme Court justices. Now, that alone is striking, but what's also striking when you dig down into Gardner, there was not a hint that there was something flawed or wrong about this process, this new process under the VJRA. And what we got was a very good decision that confirmed the legitimacy of this court and the legitimacy of the process under the VJRA. The Supreme Court could have done a lot of different things. They can raise their eyebrows. They can put little sneaky phrases into their opinions, questioning whether this court is really a court, et cetera, et cetera. They did not. So fairly early on, Brown v. Gardner confirmed that this was a perfectly acceptable process and a perfectly acceptable Federal Court of Appeals. But that's all past. And I look here in this room, and what I want to say just a couple words about is future. Future. And I've come to the conclusion that this process of handling veterans' claims appropriately needs a community. It's not, we can't have just a single actor. As important as this court is, the court staff is crucial. I watched the court staff on a number of occasions deal with the pro se claimants, the pro se appellants. They submit Christmas cards and photographs and credit card bills because they don't know how to put together a record. They don't know anything about a federal appellate court. I watched the staff of this court deal with so many of those pro se appellants with ultimate sensitivity, dignity, and professionalism. Judge Davis, one of the hidden jewels of this court is the staff. But community. It's not just the court and it's not just the court staff. It's the practitioners, the advocates. And I'm looking around this room. I see Bart Stickman sitting here. He's going to speak next. Bart has devoted almost his entire professional life doing work for veterans. Maybe I shouldn't mention his name because I also see in this room quite a number of other people who are doing very much the same thing. I see Rory and Diane and Alice on the court staff. I'm very grateful for everything you have done because you've done something very special. I thought a few years ago that this process was going to become an old boys club. Old and boys, and nobody else. That hasn't happened, and I'm so grateful for that. The advocates who are non-lawyer advocates, non-lawyer practitioners, if you read the first few volumes of Vet App, one of the most commonly occurring names as a veterans advocate is Rick Surratt, Disabled American Veterans. Rick never saw the inside of a law school, but he has handled lots of cases before this court. I worked with him on a couple projects a number of years ago, and what I can tell you is that Rick forgot more veterans law than I will ever know. He was that good. Non-lawyer practitioner. The other members of the community, the VSOs, NOVA, the Veterans Bar Association. I can go on and on. The Pro Bono Consortium, really important. But again, as part of the future, law schools. One of the things I'm proudest of when I was dean at Catholic is I commissioned what I believe to be the very first law school course in veterans law. It was taught by Linda Blahat from PVA, and it was a legitimate credit-bearing law school course. Now, other law schools, as you know, have clinics, and that's perfectly appropriate. But I think we had the very first course in veterans law. Might be wrong. I'm not entirely sure about that, but we were at least one of the first. Now we see lots of law schools coming on board. Veterans clinics, I think those are great. Now cynically, and a little bit pejoratively, I'd like to ask them, where were you 30 years ago? And I'm not sure they have a good reaction to that. But community. You're part of this community. You're the future. And that's why I'm so pleased to be here. And I want to do one thing to finish up. I want to take off my professor hat, and I want to stand in front of you as a disabled veteran. And I'm speaking to the community. And the last thing I want to say to you is, thank you. Thank you.
Thank you, Professor Fox. There is indeed a very vibrant community here now, over 30 years, and it's one of the things that I've enjoyed interacting, some of the things I've enjoyed interacting so much with is this vibrant veterans community. Thank you for those enlightening remarks. As Professor Fox indicated, Bart Stickman is our next speaker. He's Executive Director of the National Veterans Legal Services Program and the 4th President of the Court of Appeals for Veterans Claims Bar Association. I refer to Bart as a founding father of veterans law. He is the executive director of the National Veterans Legal Services Program that he helped found in 1981. He has devoted his entire legal professional career to assisting service members, veterans, and their families receive the federal benefits to which they are entitled. He's testified before Congress regarding the issue of judicial review for veterans long before the court was created. His litigation efforts have resulted in payment of billions of dollars in federal benefits to hundreds of thousands of disabled veterans and their families. Mr. Stitchman helped organize and has served over the last 27 years as a trainer for the Veterans Consortium Pro Bono program. He is also the lead co-author of the Veterans Benefits Manual, NVLSP's 2,200-page treatise on veterans benefits law. And I am pleased to welcome Bart Stitchman.
Thank you, Chief Justice Davis. I want to focus on the impact I believe this court has had over its last 30 years from the perspective of someone who's represented appellants before the court during that entire period. The court should be proud today that through the force of its precedential decisions, it has transformed the VA claims adjudication system into one that is much fairer to veterans than the VA system that existed prior to the VJRA. In short, the impact of the court's precedents has given veterans a much better chance of actually being awarded the VA benefits they have earned through their service to our country. One need only look at the annual reports of the BVA chairman over the last 40 years. In the 9 years prior to the VJRA, the BVA ruled in favor of the VA claimant, in whole or in part, in 13.1% of all appeals. A percentage that varied so little that VA skeptics thought that the BVA had a 13% quota. After the court began to issue precedential decisions, the rate of success at the BVA steadily increased, so that over the last 3 fiscal years, the BVA awarded all or some of the benefits sought in 30 to 36% of all the appeals it reviewed, 2.5 times the pre-VJRA rate of success. Just as significantly, the percentage of BVA appeals remanded to the VA regional office mushroomed after the VJRA. For the 9 years prior to the VJRA, the remand rate at the BVA varied from 13 to 20%. After the court started issuing decisions calling the board to task for not ensuring compliance with the agency duty to assist the claimant and other obligations, the remand rate steadily increased, so that over the last 4 years, it varied between 39% and 46%. Many of these remands undoubtedly resulted in an award of benefits. The bottom line is, before the VJRA, the board would consistently denied benefits in over 2/3 of the appeals. Today, the board denies benefits in about 20% of all appeals. Time does not permit me to discuss the court's array of impactful decisions, but the precedential decision in Colvin v. Derwinski serves as a fitting example of a positive court-imposed change to the VA claims adjudication system. During the days before the judicial review, the BVA decided appeals in panels of 3, 2 lawyers and 1 physician. The practice of the board at that time was for the physician board member to use medical expertise and develop his or her own medical opinion about the medical issues relevant to the appeal, like whether there's a medical nexus between the in-service disability or injury and the current disability, Often the physician convinced the two lawyer board members to incorporate the physician's medical conclusions in the board's final decision. In other words, the physician board member was serving as both an evidence giver and a judge at the same time. The court ruled in Colvin that the board could not legally base medical conclusions on its own unsubstantiated medical opinions. The board may only consider independent medical evidence in the record. Over the next year and a half, the court literally vacated and remanded hundreds of BVA decisions based on a Colvin error, requiring a new decision based only on the medical evidence in the record. This ultimately led the board to transfer all of its physicians out of the board and to use only lawyers as board members. The court's precedential decisions would not have transformed the VA claims adjudication process as much as it has if the court had not successfully engineered its way out of the pro se problem it encountered when it first opened its doors in 1989. There were very few lawyers knowledgeable in veterans law when the VJRA was enacted. Not surprisingly, the court had about an 80% pro se rate at that time. The court accomplished a dramatic turnabout. First, by asking Congress to reappropriate part of the court's budget and use it to fund a pro bono program, which led to a federal grant to the Veterans Consortium Pro Bono Program, which has for 27 years now placed worthy pro se appeals with thousands of private bar attorneys who were recruited and trained by the consortium. The court promoted veterans law and publicized its existence by each year holding a number of oral arguments at law schools around the country. The court proactively engaged with the CAVC Bar Association and otherwise encouraged the growth of the court's bar by participating in veterans law training events for lawyers conducted by the Veterans Consortium Pro Bono Program, the ever-growing National Organization of Veterans Advocates, and others. Congress contributed in 2007 by amending the law so that private attorneys could charge a fee at the administrative level after the initial denial of the claim. The end result is that today, appellants are represented before the court at the time briefing is completed in 89% of all appeals. And the court's bar now consists of over 5,000 non-government attorneys. While this is a celebration of the court's first 30 years, let me briefly turn to the future impact of the court. I hope and believe that the court will increasingly rely in the future on precedential decision-making. In the last 2 fiscal years, 98% of the appeals decided by chambers were non-precedential decisions issued by a single judge. In the near future, the court will be called upon to interpret the Veterans Appeals Improvement and Modernization Act of 2017 and the VA 2019 regulations implementing that landmark legislation. These judicial interpretations should be contained in precedential decisions. The court's future exercise of its class action authority, confirmed by the Federal Circuit in Monk, can also have a major impact on whether veterans are actually awarded the VA benefits they have earned through their service to our country. For this court, the first 30 years is only a way station on its journey. Thank you.
Thank you, Bart, for those insightful remarks and food for thought. Appreciate it. Jack Thompson is our next speaker. He's the former deputy General Counsel at the VA and the first president of the Court of Appeals for Veterans Claims Bar Association. Jack retired from the Department of Veterans Affairs after serving as its Deputy General Counsel, VA's top career lawyer, for 15 years. In that role, he led day-to-day operations of 700-plus member office of the General Counsel, VA's National Law Office. An Army Reserve veteran, he spent his entire professional career with the VA, beginning in 1973 as a staff attorney with the Board of Veterans Appeals. He joined the Office of General Counsel in 1977, where he assumed positions of ever-increasing responsibility. In 1985, he was appointed Assistant General Counsel in charge of all advice regarding VA's multi-billion-dollar compensation, pension, and life insurance programs. His staff prepared most of the precedent opinions of the General Counsel's office and was responsible for advocating the department's positions in appeals taken from the United States Court of Appeals for Veterans Claims to the United States Court of Appeals for the Federal Circuit. He and his team also assisted in drafting and implementing landmark legislation, including the Department of Veterans Affairs Act, which elevated the VA to cabinet status, and the Veterans Judicial Review Act, which created this court. Mr. Thompson was appointed Deputy General Counsel in 1998 and served as Principal Deputy to 4 successive presidentially appointed General Counsels. He partnered with them in overseeing the work of all of the legal staffs responsible for advising and representing VA officials. He is the only VA senior executive to have received the Distinguished Executive Presidential Award on 3 occasions, in 1995, in 2001, and in 2012. And among his many other awards was the Hart T. Mencken Award in 2006 for his outstanding service to the United States Court of Appeals for Veterans Claims as founding president of its Bar Association. He is a graduate of both the University of Iowa and its College of Law. Jack?
Well, thank you very much, Chief Davis, and my congratulations to you, to my good friend Judge Schoelen on her, both of your hard-earned retirements. And may it please this hefty bench, the VGRA was certainly the most significant legal development in my 40-year career in veterans law. And my career afforded me a pretty good vantage from which to observe the conditions of this court's creation. As was noted, I first, right out of law school, worked at the Board of Veterans Appeals, drafting decisions, and really learned firsthand how the claim system could benefit from giving claimants a redress to an independent tribunal. When legislation to confer that right was considered, I got to participate in negotiations over its final provisions. When Judge Nebeker was nominated to become its chief judge, I was part of the small group he pulled together to draft the court's rules of practice. And I stood up the legal group at the Office of General Counsel that would represent the Secretary before the court. To elaborate just a little bit, work at the Board of Veterans Appeals I thought was a great job, especially coming right out of law school, someone who liked to write. It was good and it was fulfilling work. Now, the legal aspects of that job back in the 1970s were not very complex. You see, there was no bothersome case law to have to consider. Only occasionally did we even have to consult the precedent opinions of the General Counsel. More demanding, of course, was the gleaning of all the critical evidence from sometimes voluminous claims files. We knew that we were, at that point, the veteran's last resort, and so worked hard to get it right, and I believe we usually did. But naturally, some of the board were just more perceptive and detail conscious than others. Then, as now, there were productivity expectations that could almost subliminally mitigate against exacting thoroughness in combing the files, especially the big ones. And even a perfectly prepared draft decision had to be signed, as Bart said, by a panel of 3 board members who, of course, brought their own subjectivities to bear. Now, we're all products of our life's experiences, and in the 1970s, all board members were veterans. They had to be as a qualification of the job. And many were World War II and Korean veterans. Just my observation, but I thought that they empathized most with wartime veterans, particularly those of lengthy service, without any hint of disciplinary actions against them. After nearly 4 years at the board, I joined the Office of General Counsel, where I prepared a lot of congressional testimony on legislation for VA officials. That included work on what was to become the VGRA. Now, opposition to that legislation by the traditional veteran service organizations and by successive administrations, both Democratic and Republican, thwarted its proponents for quite some time. Those of you who remember the Reagan administration know it was generally averse to expanding the size of federal government in any way. And it maintained that deprivation of property rights, including veterans' benefits, did not require judicial remedies if there existed administrative ones with the essential elements of due process. Now, at this point, because my good friend Don Ivers is here, I just want to mention that the most eloquent opponent of judicial review that the administration ever sent up to Congress was Judge Ivers. But in mid-1988, significant split developed in the positions of the major VSOs, as has been mentioned, and that turned the political tide. The final legislation came together pretty quickly once House Veterans Affairs Committee Chairman Sonny Montgomery got behind it. Now, in negotiating the bill's final provisions over those few weeks, we at VA had a few principal aims. First, the tax court model. We believed that the best route was to have judicial review that was appellate in nature in a new specialty court based on the record developed at the administrative agency. Now, those of you who weren't there may think that this seems entirely unremarkable. But at that time, there were serious competing proposals to authorize de novo trial-like proceedings in the various U.S. district courts across the country. We thought, for a number of reasons, that that would just be unworkable. Also, based on our experience with the Department of Justice, we thought these cases would be given very low priority by the department, and so we pretty much insisted on having the secretary represented by the Office of General Counsel. Fortunately, all of that came to pass. As has been mentioned, the court took a while to get up and running. Its docket was relatively light in the early months, which allowed OGC's staffing to grow incrementally as the caseload did. The initial core group of just 12 people in my office who pioneered the office eventually grew into the current staff of 123, including 82 attorneys. Wow. I understand the Board of Veterans' Appeals now employs over 1,000 people, when in 1988 it had fewer than 400. I don't know how large the court and its budget become. But on this 30th anniversary, one might ask whether taxpayers have gotten sufficient value from their investment. And of course, the answer is yes. Veterans deserve redress to an independent body when they question a denial of benefits by the department. Rulings by this court and the Federal Circuit have benefited them in ways that are inconceivable in the absence of judicial review. And it seems beyond argument, and there's been some empirical data thrown around by Bart, it seems beyond argument that just the prospect of judicial review of its decisions must cause the board to devote extra consideration to its work. My congratulations to all of you for your part in ensuring the success of this landmark legislation. Thanks very much.
Thank you, Jack. The reason I noted your education in Iowa is because I grew up in Iowa. My family's from Iowa, so when I saw that, it was nice to see. I hope you all have gotten a little bit of a trip back in time, understand where this court has come from. That was the intent of putting together this distinguished panel and group of speakers, so I'd like to thank you all for those wonderful remarks, all of you. The second part of this trifecta is retirement remarks from two retiring judges. One of us is old enough to retire.
You're talking about me.
Right. The other is not, but she's retiring anyway because she's smarter than the rest of us and figured out how to retire young. My colleague, Judge Mary Schoelen, was nominated by President George W. Bush, confirmed by the Senate, and appointed a judge of the United States Court of Appeals for Veteran Claims in December 2004. Before her appointment, Judge Schoelen served on the United States Senate Committee on Veterans Affairs. She served as the Deputy Staff Director for Benefits Programs and General Counsel from June 2001 to December 2004 under Chairman and Ranking Member West Virginia Senator John D. Rockefeller IV, and Ranking Member Florida Senator Bob Graham, and as Minority Counsel from March 1997 to March 2001. Before joining the Senate Committee on Veterans Affairs, Judge Schoelen worked as a staff attorney for the Vietnam Veterans of America's Veterans Benefits Program. In a word, Judge Schoelen has been a force on the bench, not only through her decisions, but through her energetic leadership and exceptional work on the court's Judicial Conference Committee, Legislative Committee, and History Book Committee, to name a few. Judge Schoelen?
Thank you, Chief. Usually when a judge retires who isn't a chief, there isn't that much fuss. They work until the end, and then we fet them sometimes later at a portrait ceremony. So among the many, many lucky moments in my life, I have the good fortune of retiring at the same time as a chief judge. And I get to ride on the coattails of this lovely ceremony and celebration, and the very exciting transition to a new chief judge who I know will do amazing things for this court. If I had planned this better, I would have made some notes along the way, so I would seem wise and introspective now. Nevertheless, I'm not going to waste this opportunity, but I know that today isn't all about me, so I'll be brief. And I know you're all praying that's true. It's hard to believe that 15 years have almost passed. I recall thinking how strange it was to know what one is going to be doing for 15 years. Who gets to do that? Every day hasn't been easy, but every day has been an honor and a true privilege to serve America's veterans alongside my tremendous colleagues. At the time, it was intimidating to follow our trailblazing first generation of judges. The more I learned about them from the History Book Project, I realized I should have been even more intimidated when I stepped on the bench. Chief Judge Davis and I have been fortuitous in the opportunity to be a bridge, serving with the last of the original judges as well as the next generation that's going to lead this court. Thank you all. I've learned so much from all of you and enjoyed getting to know every one of you. It's been very fulfilling to get to know the attorneys who practice before the court, along with the many folks who work at the board. I'm so inspired by the collegiality that I see at Bar Association events and at the Judicial Conference. I'd like to thank the entire court family, specifically thanks to the marshals, CLS, the public office, the clerk's office, IT, and admin. Admin gave me my first home at the court. For my first year at the court, we had more judges than chambers, and I had an office on their 9th floor hallway, where I gained invaluable insight into the people there and the jobs they do that make the court work so the judges can do the work of the court. And they're the ones, along with the marvelous Alice Kearns and Stephanie Allen, who pull events like this together. I never had children my own, so I don't know exactly what it feels like, but I joke that when a clerk leaves, it's a little like they're graduating or moving out of the house. I take such pride in seeing their growth as people and lawyers, and yes, I know that lawyers are people too. I revel in their accomplishments and those of my grand clerks. I insist they visit and send pictures and recognize that they have given me way more than I've given them. I have to thank Lorraine Swisher and Patty Lewis.
You're not supposed to do that.
I was trying not to. My assistants during my years at the court. They've helped me in innumerable ways and have generally been successful in keeping me sane, doing it always with a smile. I'd like to thank former Senator Rockefeller and his personal office and Veterans Committee staffs who worked to make a crazy dream I didn't dare dream a reality. My father's here today. Commander Lawrence Schoelen, U.S. Navy retired. I thought I was going to get through this. I even practiced. Thank you, Dad, for showing me what commitment to duty and service to our country look like. Okay, that's done. My big brother Larry and his wife Kimberly are here today. He's the one who really made all of this possible. He let me live with him during my first year of law school when I moved here to DC, so thank you. Finally, I must thank my wonderful and supportive husband, Brad Smith. He's my official PR agent, always bragging about his judge wife. I hope he doesn't get sick of me when I'm hanging around the house all the time. Again, it's been my honor and my privilege to serve America's veterans and their families on this court and with these people. Thank you.
Right. Very nice. How do you follow that, right? I'd like to thank my mother, who is here, my sister and her husband, for making the trip from Florida. Obviously, your family background and the principles that she's helped to instill in me and all of us have gone a little ways. I'd also like to thank my uncle Michael Horowitz and Deborah on the second, Deborah Marcus on the second row, who have been my family here in Washington, beginning way back to 1975 when I was a law student here. I see many friends and former law clerks in the audience, and I'm not going to start naming you because we could be here for a while, but it touches my heart to see you all. I'm looking forward to the party afterwards, and I'll look forward to catching up with most of you at that time. I appreciate you making the effort to come here today. Let me simply say that working with all of you in the veterans law community and getting to know many of you has been the highlight of my career. From the members of the practicing bar appearing before the court and serving on a variety of committees, the Department of Veterans Affairs Office of General Counsel, the Veteran Service Organizations, the clinical programs at the law schools across the country, the organizations like the National Veterans Legal Services Program, the National Organization of Veterans Advocates, to the Veterans Pro Bono Consortium, with your commitment to assisting veterans in efficiently resolving their claims and pursuing the greater goal of improving a claims and appeals process at the department and at the court, we have made great progress in 30 years. This court has been and is a wonderful place in which to work and tackle tough legal issues. We have a true and honest mission to provide prompt and fair process and justice for veterans. During my 15-year term on the court, I've had the privilege of working with some of the most dedicated and talented people I know. Anytime you run an operation with 125 employees, Jack, and $33 million budget, you have a lot of people to thank, because it's those people who help to keep the operation running efficiently. Many of them are what we call unsung heroes, because they're usually in the background and don't get the spotlight often. But without each one of them doing their jobs, we would not be successful in accomplishing our mission. We have endeavored to recognize them through pay increases, promotions, our merit-based awards program. But if you would permit me, I would like to spend just a couple of minutes singing about them just a bit. That way, they will be sung about heroes rather than unsung heroes. If you would please, well, let me start with Ann Steigels in the public office, who is on the front line of case intake and processing, and Judge Schoelen made reference to these offices as well, and her staff. Ann and your staff who are here, could you please stand for just a second? Okay, great. Thank you very much. To our most talented legal editors who get to review and recommend edits for all of our thousands of opinions. Laura and Pat, are you here? If you are, please stand. Thank you. To Cynthia Brandon Arnold and the central legal staff, which is also at the front lines of processing cases and significantly resolving cases through the Rule 33 conferences. With you folks from the central legal staff, please stand. I was going to read all of your names, but I decided that's probably not a good idea. So, Kendall Benson in our Office of Information Technology, who keeps us up to date with advances in technology and outfitted with the best hardware and software on the market. Kendall and your staff, please stand. The court's executive officer, Greg Block, and his immediate staff, who have been my administrative partners for the past 3 years while I served as chief judge in pushing a variety of projects and initiatives aimed at moving the court forward on a variety of fronts. Please stand. Where's Dawn? Our deputy executive officer, Patrick Barnwell, who handles all aspects of our administrative operations involved with running an operation with 125 employees. Patrick is standing in the back, and your staff. Thank you. Eva Arma, our outstanding accountant and efficient director of finance and budget office. Would you please stand, and your staff. Our excellent librarian, Allison Fentress, who has been so good at everything she does at a time when libraries are adapting with technological changes, and most recently helping the authors of our history book project with access to various documents. Allison, if you're here, please stand. Our talented general counsel, Kerry Sklar, and his talented deputy, Amy Wilkinson Hagan. Would you please stand? Amy's in the back. Okay, thank you. They often give me advice that I don't want to hear, but I usually listen to it anyway. I think I've managed to stay out of trouble. I have a couple more weeks and I'll be good. Thank you. And to our most dedicated and vigilant United States Marshals who ensure the safety of all of us working in our building, Sam Woodson, James St. Hilaire, and Ron Royster. Let me thank all of my colleagues, active on the bench, seniors as well, and their staffs for their commitment to our mission. They have been a very engaging group of jurists, sometimes contentious, but always collegial, and it's been a privilege to work with all of my colleagues. We have laughed at Board of Judges meetings more than we've ever laughed before, so that was nice. I'd also like to give special recognition to my own chamber staff and law clerks who throughout my 15-year tenure on the bench have been truly remarkable. From my first 4 law clerks, Angel Caracciolo, Jeff Goldberg, Condi Kleinman, and Marcos Arauz, and my first confidential assistant, Sharon Gisclair, to my last group of clerks and confidential assistants, Sherry Toby Williams, Stephanie Allen, all of my immediate clerks, Amanda Blair, John Gaffney, John Washleff, Ben Tesfaye, and Cassandra Vangelo. Thank you all very much. In my last 3 years as Chief Judge, to all of those people who I directly supervised, in particular Alice Kearns, Counsel to the Board of Judges, and to the 6 recall clerks, to a person, each one of you contributed in so many ways to helping with many projects and events and in assisting me with my very demanding schedule as Chief Judge. You all contributed to the mission of the court to provide fair process and justice for veterans. I will not chronicle our accomplishments or where we fell short, but we worked hard and moved the court forward. I've truly loved being your Chief Judge, and I've loved the opportunity to serve all of you, our veterans, this court, and this country. The third part of this ceremony is the passing of the gavel. Judge Margaret Bartley was nominated by President Barack Obama, confirmed by the Senate, and appointed a judge of the United States Court of Appeals for Veterans Claims in June 2012. Before her appointment, Judge Bartley worked for more than 17 years as a veterans advocate, serving as staff attorney and then senior staff attorney for the National Veterans Legal Services Program, a veteran service organization. In that capacity, she advised and trained staff and service officers for the American Legion, the Military Order of the Purple Heart, Vietnam Veterans of America, other veteran service organizations, and state departments of Veterans Affairs on veterans benefits and veterans preferences in federal employment. She also represented veterans and their survivors in their pursuit of VA benefits before the court and the United States Court of Appeals for the Federal Circuit. From 2004 to 2012, Judge Bartley served as the editor of the NVLSP Veterans Law Quarterly, the Veterans Advocate. She also testified before Congress concerning federal agency failure to apply veterans' preference laws and appeared on behalf of amicus curiae in several significant veterans' preference cases. From 2005 until her appointment to the bench, Judge Bartley also served as Director of Outreach and Education for the Veterans Consortium Pro Bono Program. In that capacity, she organized nationwide training for lawyers interested in representing veterans and their survivors pro bono before the court. Before her career as a veterans advocate, Judge Bartley served on the court as a judicial law clerk to the late Judge Jonathan Steinberg. And I see his wife in the audience. Shelley, it's very nice to see you. Thank you for coming. For the past 7.5 years on the bench, Judge Bartley has made her mark at the court not only through her decisions, but by serving on key court committees like the Judicial Conference Committee and the chairing the Budget Committee and the Court's Outreach Committee. So, ladies and gentlemen, it is my distinguished pleasure to pass this gavel to my colleague, Judge Bartley. Judge Bartley, could you please rise? As the next Chief Judge of the United States Court of Appeals for Veterans Claims.
I've learned my first lesson: when you bang this gavel, it doesn't really do too much, because I was banging it while you were clapping. Thank you all so very much. Wow. Looking at all the former chief judges here and my current colleagues and retired judges and everyone who is here on the bench, I think it's clear to each and every one of you that I have very big shoes to fill. I'm looking forward to it. I'll do my best to fill those shoes and to continue to improve the court and ensure that veterans receive justice. Anyone out there in the audience or on the bench with me who has advice, counsel? I've already asked a few of you what changes you would make at the court. I didn't have to ask Mr. Stitchman because he was very forthcoming just now in his speech. But really, anyone who wants to lend a hand and give advice, I am definitely willing to listen, since I am more of a listener. But I'm also a very active person. Now, before I go any further, I want to add my thanks to Judge Davis's and thank all the visiting judges who took time out today to attend. I really appreciate the time that you're spending, and I look forward to working with you. Same with the VIPs from the Department of Veterans Affairs. Same with VIPs and staffers from veteran service organizations. I look forward to working with you, and from the advocacy community. I'm looking forward to it. I also want to thank those family and friends and colleagues and former colleagues who have come to support me. Many have come from very long distances, South Carolina, Florida, well, 2 people from Florida, a former intern, from South Carolina rather, Massachusetts, Ohio, Pennsylvania. I even had people drive, well, it would be an exaggeration to say through the night, but they left a Elton John concert last night, and here they are today. I'm not sure what kind of a chaser this is for an Elton John concert, but maybe the reception afterwards will prove to be a lot more fun than you all were anticipating. I want to recognize just a few people personally. My husband, Charlie, who I was lucky enough to find by total chance around 26 years ago. I'm definitely a better person because of him. My daughters, Eve and Muriel, they're in the front row. They are independent and strong-minded, and they keep me on my toes. And they serve to remind me that the legal universe that I inhabit, that we all inhabit, is just a tiny speck of all the interesting things that someone can do with their life. And those other things are important. This is important. Believe me, this is important to me. But it's, you know, there are other things, and those things are important as well. And my daughters have really helped me learn that. Same with my son-in-law, Kenny, who is in the second row. I love all of them so much, and I'm very proud of them. I have 2 grandchildren. One is here and one is absent. I have a granddaughter, Lily, who's not here, and a grandson, Gideon King, who is here. He's in the second row, and if you've seen me smiling throughout other people's presentations, it's pretty much because I'm like looking at him and seeing what he's doing. And I don't know whether to be proud that you haven't heard a peep from a 5-year-old, but I don't think you should be proud about those things, but I am a little bit proud of it. Those children are the light of my life, really. I'm almost done here. I also want to recognize my law clerks, former law clerks, and law clerk interns who are sitting over here, many of them in the box to my left. And I see a few are out in the audience, Dale Ton especially, and I'm sure there are 1 or 2 others. But they have made me look so good on paper in the last 7.5 years. And I want to recognize them and thank them, especially my soon-to-be executive attorney, Dan DeLucia. Dan, raise your hand, please. And my soon-to-be senior law clerk, Tom Susko. But really, and Tom is right next to Dan. And they can read minds, and the same with my other clerks and former clerks, and thank you all. I'm especially sorry to see the two retiring judges that I've served with for the past 7 years. Chief Judge Davis, I'm still calling him Chief Judge until December 3rd, which is his last day. So that's why there's kind of like two chief judges now, but it's really only him. I'm so sorry to see them leave the court. Judge Davis has been such a great emissary for the court. He started the Judicial Advisory Committee. He increased our outreach to the public. He shepherded us through many of the steps necessary to almost finally come up with class action rules. And he's a great person. Judge Schoelen, I don't think I need to say anything really. Everyone who knows her thinks that she's absolute tops, and there's not a whole lot more to say. But the thing about Chief Judge Davis and Judge Schoelen is that they have a lot of legal acumen, don't get me wrong, and that is very important. But I think the best thing about them is that they're good people to work with, they're collegial, they're even-tempered, they maintain balance in their lives, and they're nice people who have really only had a single goal, which is it's complicated in practice, but that single is very complicated in practice, as we all know. But that single goal is just trying to do what they believe is right for veterans under our current laws, and under some past laws too, once in a while. So that's their goal, and they've done it amazingly well, and been a pleasure to work with as well at the same time. Now, really for the past 5 years, people have been asking me about my initiatives. What am I going to undertake while I'm chief? And I'm glad I didn't plan too far ahead, because who would have thunk that several years ago, by the end of 2019, we would have already handled several class actions, that we would have a whole new VA benefits procedure by law, and that we would be entrusted with interpreting it in the future. So I didn't do any prognostication about what my initiatives were going to be until very recently, and even now I am only going to be kind of vague about them. I'm going to let you know I'm going to be guided by 3 principles in considering initiatives. First, the basic thing is we have to keep in mind our primary concern at the court is veterans and their appeals and petitions. Like, that's it. That's my life. That's the working life of everyone on the bench here. And so any effort that we can start to decide the appeals and petitions correctly, which is our primary concern, and swiftly, which is an important concern, but I believe a secondary concern, that's what I'm looking to continue and enhance. That's my #1 priority. We did this in the last year. The court recently made some changes to Rule 4 to loosen our filings for notices of appeal, late notices of appeal. You know, we would always get notices of appeal 1 day late, 2 days late, a week late, 2 weeks late, and our courtroom door would close. Well, we changed the rule. I think it's having some effect, and the rule changed to reflect some of the leniency that is in the federal rules of appellate procedure. That's what we did. That's what we did, and for one, I'm really proud of that. I'm looking to do more of that, because we have to ensure that veterans get at least as much process as non-veteran appellants get in other courts. That's like a basic for me, if you want a basic. That's a basic. They shouldn't get less process at our court than appellants at other courts. So I'm proud of that, and those are the types of things I look forward to working on. Second, I want to keep our incredible, hardworking court staff. I want to keep them happy with the most beneficial work and pay policies that they deserve. And that's another effort that I'll undertake. Now, the chief took a little bit of the wind from my wings by making every court group stand up, because I was going to recognize a lot of those groups. But I will say that we have, in the last 2.5 years, doubled the number of appeals we're receiving. And you know what? We have not doubled our staff. Not even close at all. And so I want to keep that staff happy, because it's my nature to keep people happy, but also because they really deserve it. Hands down, there's no arguments from me. So those kinds of initiatives are important to me. And I look forward to working on some things, even though I have to admit that Chief Judge Davis and other judges before him have been acted absolutely wonderfully in this area. But perhaps we can mine some more and make people happier. Okay. Third principle in considering initiatives, my third principle, this really shouldn't be the third, but it's really maintaining collegiality among the judges of the court. That's very, very important to me. Keeping it respectful, not being too hard on each other, and knowing that we're all trying to do the best that we can. We disagree seriously sometimes. I could name you about 5 cases right now where we're all disagreeing seriously. These are not, I'm not going to get into, I'm not going to talk too much about that, but when you feel strongly about your interpretation or your view of the law, that can bleed over into how you feel about the person who's taking the opposite or a very different position on the law, and that really runs to the detriment of the entire court. And one of my principal determinations is not to let that happen and to keep things collegial, which Chief Judge Davis and judges before him have also done. But it can be a struggle depending on the personalities involved. It can be a real struggle, and it's very stressful. And I said it really hurts the entire court when we have that kind of thing working. And so one of the things I want to do is prevent that if possible. But I am going to wrap it up now. I look forward to working with all active judges and recall judges to accomplish some changes in the areas that I just mentioned. I do want to say one other thing. I'm remiss. Over in the box to the left is Mary Alford, who is my assistant, and last night my younger daughter Muriel called Mary an angel, and she was serious. And Mary does amazing work and has just been of enormous help to me, and so thank you, Mary. And I know she's going to continue to do that. But anyway, I'm wrapping up. I look forward to working with everyone here and having a steady course through the next few years. I do want to settle one thing before we leave, and this has to do with Professor Fox's comment about reasons and bases, or reasons or bases. And I'll just say that the line from this court right now, speaking as a soon-to-be chief, is that it's reasons or bases, because that's what the statute says, and because we would not want to put a higher burden on the board than the statute requires. So that's my 2 cents. Before we adjourn, anyone else I didn't name in person, I thank you for coming, and I look forward to talking to you during the reception. Before we adjourn, though, I want to thank the court staff, the staff at this courthouse, who have been instrumental in having this event work well. And it's been a wonderful celebration of our history and our life at the court. Let's wrap it up and continue the festivities at the reception. And without further ado, this ceremonial session is now adjourned.
ladies and gentlemen, for coming today.